You are trash, Lindsay. You are trash.
All right,
David, that
isn't appropriate.
You're calling me crazy. You're my attorney. I told you I was abused by that staff.
I understand. David, let me just finish, okay? And then if you find that
I'm not going to sit here and let you call me crazy.
I wasn't calling you crazy.
You just did, ma'am.
No, David, I was
abused, discriminated against. I was robbed.
Sir,
my room was ransacked several times.
Sir, listen to me.
My room was vandalized.
You're either going to stop and let her finish this hearing, or I'm just going to end it and I'll do this hearing a different time.
Whatever.
Yelling at his parole revocation hearing. But before we watch it, we're going to take a flight back to the past 2 weeks prior to his preliminary hearing, where he makes a decision that maybe he regrets. With that, let's jump.
Good morning, Mr. Newman.
Yeah.
How are you?
Huh?
How are you?
Not well, thank you.
Okay. So this is your preliminary hearing that I have scheduled today.
Uh-huh.
But I wanted to ask you, do you want an attorney for your preliminary hearing?
It's not necessary.
You feel okay having the hearing without an attorney?
No, I better have an attorney because this is a bunch of hoopla.
Okay.
I need an attorney because my PO is a sick maniac. I have committed no crime. The evidence is all hearsay. It's all bullshit.
Okay. So how about this? How about I refer you to the public defenders, and so you can get an attorney for this hearing, so you can have somebody to represent you.
Yeah, that would be nice because it's all made up. I have committed no crime. They told me I'm here for not taking insulin, which is the craziest thing I've ever heard in my life.
Okay, so
my parole officer is a nut job.
Okay, so what's going to happen is that I'm going to refer you to the public defenders, and they're going to reach out to you, and they're going to talk to you, okay?
That would be great.
But I will see you. I'm going to put you on my next scheduled hearing date, which is on April 16th, okay? So it's in about a week and a half. So I'll see you again in a week and a half, okay?
Okay, will do.
All right,
I
thank you.
appreciate it.
Yep, no problem.
They'll come visit me?
So say that again?
The public defender will come visit me?
I think they'll call you on the phone. I think you'll talk to them on the phone, okay?
Oh, all right. Yeah.
Okay.
Sure.
All right. So they'll be calling you, okay? Expect them to call you.
Yeah, I appreciate it. This is really a bunch of nonsense. I've done nothing wrong. They made up a lot of stuff in that report.
Okay.
It's really crazy.
Okay, so I'll see you again in a week and a half, and you'll have an attorney, okay?
Okay. Thanks a lot.
All right. You're welcome. I'll see you again.
Okay. I think I have to wait here. Don't come visit me.
So say that again?
The public defender will come visit me.
Mr. Newman, you're all set, okay? So you can go back, and I'll see you again.
Newman 323-865.
Thank you. And I do have your attorney here via video as well. Can you identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Newman.
Thank you. And I do have your parole officer as well. Can you identify yourself for the record?
Good morning, Parole Officer Lindsay Carrington with the Parole Mental Health Unit.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there's probable cause to believe that you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious enough to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there's probable cause to believe that you violated one or more conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious enough to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you, and this hearing is being recorded. You have important rights at this hearing, which I will now review with you. You have the right to be represented by an attorney at this hearing, and you do have counsel representation today. You have the right to receive written notice of the charges of violation. Did you receive written notice, sir?
Of what?
Of the charges of what you're being charged with?
Yes, it was completely ridiculous.
Okay.
What I had.
Okay, so
you
we'll get into
received
that. We'll get into that in a second. I just want to make sure you got the.
Yeah, I did. It was quite ridiculous.
Okay. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, sir?
Yeah.
Okay, I'm going to place you and P.O. Carrington under oath. Can you please both raise your right hand?
Mm-hmm.
You solemnly swear and solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury.
Yes.
Yes.
All right, thank you. All right, so we're going to review your charges that your PO is charging you with. PO Carrington, do you have the notice in front of you?
Yes.
Okay, perfect. All right, charge number 1, condition of halfway house placement. Your PO reported.
On the following dates, you refused to take your prescribed medication of insulin: 2/9/24, 2/10/24, 2/12/24, 2/13/24, 2 doses, 3/9/24, 3/10/24, 3/11/24, 3/12/24, 3/13/24, 3/14/24, and 3/15/24. This is a violation of the signed halfway house agreement and your parole condition of halfway house placement. On the following dates, you refused to take your prescribed mental health medication of Zepacol: 2/1/24, 2/2/24, 2/5/24, 2/12/24, and 2/13/24. This is a violation of the signed halfway house agreement and your parole condition of halfway house placement. On 2/13/24, you were observed on camera going in and out of the bathroom multiple times during third shift. Staff went to check on you and found the bathroom smelling of cigarettes with smoke in the air. No other clients had access to the bathroom at this time. On 2/2/24, you became combative with the program staff and refused to follow staff direction. You refused to listen to staff and entered the staff office after being instructed to wait. You called staff a racist asshole and a racist fuck. This is a violation of signed halfway house agreement and your parole condition of halfway house placement.
And charge number 2 of mental health treatment, your PO reported.
On the following dates, you refused to take your prescribed mental health medication of Depakote: 2/1/24, 2/2/24, 2/5/24, 2/12/24, and 2/13/24. This is a violation of signed halfway house agreement and your parole condition of halfway house placement and the mental health treatment.
All right, thank you. So those are your charges, sir. I do have evidence from the state. Exhibit A is a signed parole condition. B, remand to custody. C is signed notice of parole violation. D is a parole violation report. E is offender misconduct. F, signed medication refusals. G is Davis House incident reports. H, hospital discharge paperwork. I, signed halfway house agreement. J, Davis House client handbook. K is a signed PEC. L, audio recording of transport. All right, and that's what I have from the state. So at this time, the state will have an opportunity to make a short statement, call any witnesses, or speak to any evidence. P.O. Carrington, is there anything you would like to say at this time?
Sure. David was placed at the Dana's house, which is mental health halfway house, on January 18th, 2024. Prior to his placement there, while still at Garner, he had been diagnosed with diabetes and was placed on medication for his diabetes. Upon coming to Dana's house, he was refusing to take his insulin. During the 2 months that he was here, he was very aggressive with staff, very agitated. His behavior was very paranoid, stating that the insulin had cyanide in it. But at the same time, we attempted to work with him in every which way possible we could to stabilize him and he was resistant to every attempt. So due to his, his increased instability, refusing medical services, refusing appointments, refusing his medications, it was in our best interest to place him back into Department of Corrections, as he needed a higher level of care than what we could provide here at the halfway house. At this time, we are trying to work on a higher level of care for his discharge, which may incorporate an inpatient hospital setting, because he clearly just can't manage in the community in a halfway house, unfortunately. So that's what we're working on for a plan for his discharge.
Okay, thank you. Defense, is there anything you would like to say regarding the charges?
Yes, thank you. In regards to charge 1 under halfway house placement, in regards to the paragraph beginning February 13th of 24, I would just point out that there is no observations of Mr. Newman smoking in the bathroom. There's simply observation of smoke and the smell of smoke, but it doesn't indicate that staff actually witnessed him to be smoking.
They all have smokes in their rooms. They smoke blunts in their rooms.
Okay.
I'm the only one that was.
All right, David, just let me finish, okay? And then if you have something to add at the end, okay? All right, thank you. In regards to the last paragraph that I believe begins February 2nd, 24, regarding his combative behavior. I mean, I certainly don't condone my client being disrespectful to staff, but I think that we are dealing with a illness here, and that that's very obvious that that's a result that conduct is a result of Mr. Newman's illness. In regards to charge 2 under mental health treatment,
I just have to say, I was abused in that halfway house. That's what I was sticking up for my rights, calling them racist. I was discriminated against and abused. That's why I called them a racist fuck. You are trash, Lindsay. You are trash.
All right,
David, that
isn't appropriate.
You're calling me crazy. You're my attorney. I told you I was abused by that staff.
I understand. David, let me just finish, okay? And then if you find that
I'm not going to sit here and let you call me crazy.
I wasn't calling you crazy.
You just did, ma'am.
No, David, I
was abused, discriminated against. I was robbed. My room was ransacked several times.
Sir, listen to me.
My room was vandalized.
You're either going to stop and let her finish this hearing, or I'm just going to end it and I'll do this hearing a different time.
Whatever.
So you need to stop and let her finish.
I'm not going to be called crazy, ma'am.
She's not. She didn't call you crazy.
I have 2 ears and a brain. Excuse me.
Attorney Jones, go ahead.
Thank you. In regards to charge 2 under treatment, again, I would just point out Exhibit H, which was the after-visit summary from Yale New Haven Hospital that indicates that he entered that facility on February 6th of 24. Again, the instructions state that your medication has changed and you are to stop taking. Again, metformin is added. So presently, Mr. Newman is not. Exhibit K, which is the physician's emergency certificate from February 14th of 24 at the Dana House, indicates that the patient is not taking prescribed medication. And we would point out that that medication was stopped on February 6th of 24 when he was at Yale New Haven Hospital. That's leaving approximately 3 dates where he's alleged to have not taken that medication prior to being seen at Yale New Haven, where the medication was ordered stopped. And simply, I would just argue that if he was ordered to stop taking that medication on February 6th, I certainly don't think that on February 5th, the day before, or 2 or 3 days prior to that, that it really makes a difference whether he was taking that medication. Obviously, the physician at Yale indicated that they wanted that medication stopped for a reason. And if I can just add in regards to seriousness,
Go ahead.
I would just, again, point out that my client is no longer required to be taking Depakote. That is part of the violation. So I think that leaves us really with whether or not he is required to take insulin and is refusing to take insulin. And I certainly, you know, I don't know exactly what was happening. In my conversations with my client, he does tell me that he was taking insulin in pill form and that he did not want to take it by way of injection. He does report to me, and I don't have verification of this, though I attempted to verify this through my social worker. He's telling me that he is presently taking insulin in pill form while in the Department of Corrections now. And again, I don't know, I don't have a way to verify that. Perhaps Parole Officer Carrington has a way to verify that, but I don't. But in any event, he seems to be, if that's accurate, then he seems to be stabilized on his insulin. And I certainly don't think that we should be considering the Department of Corrections as a higher level of care for a medical incident. So I would be submitting that it's not serious enough to warrant further detention. I would be asking that he be released into the community, and that the higher level of care that is being required or being requested be conducted through by way of community, by way of him being in the community, as opposed to him being within the Department of Corrections.
Thank you. P.O. Carrington, anything you want to add?
Yeah, hospital, and then his prescriber, his psychiatrist, Dr. Peacock, had restarted that when he returned back to the program.
No, he didn't. No, he did not.
As far as his compliance currently with his insulin, I received notice yesterday that he is not compliant with insulin currently at the facility.
Okay,
It's
so
a
if I could
toxic
just,
dose. It is a toxic dose. I'm not stupid. I'm not going to take a toxic dose of insulin. I'm not an idiot.
If I could just comment on, just briefly, I don't believe we have any evidence it was re-added after he was discharged from Yale New Haven. And certainly that's confusing. If you're discharged with paperwork that indicates you're to stop taking a specific medication, I think that's very confusing that it's later added by another doctor a week later. And there, again, there's no indication that it was added by the doctor, other than the emergency certificate indicating that he wasn't taking it. There's nothing that addresses the fact that Yale New Haven stopped this medication, but I'm re-adding this medication. I don't see that anywhere in any of this documentation. And so again, if Mr. Newman is not presently taking insulin, then I don't understand how he hasn't had any sort of medical emergency that we're aware of, if that's required for him to be taking that. Again, I just would be asking that he be placed back into the community so that he can receive a higher level of care in the community. I don't think DOC is the appropriate avenue for a higher level of medical care. Thank you.
It's better than a hospital.
Thank you. All right. Anything else?
Lindsay,
I
you are
just, you know, I
trash.
think that his behaviors and his level of agitation,
Because you
documented
violated
both
my
in
rights,
the-
Lindsay. You abused your authority. You
in the
abused your
violation
authority.
report.
You haven't, she
Sir.
has not met with me once since I
Sir,
was in
can
that
I-
halfway house.
Can I ask you to wait until P.O. Carrington finishes, and then I'll let you speak if you want to say something, okay?
Oh, well, okay, sure.
Okay.
I think his, you know, his level of agitation today is just a piece of what we were seeing while he was in the community, which is why we
Because I
can't
can't
manage him in the
stand you. You
community.
tell all lies. You're sitting there lying. You're a piece of trash.
All right, sir, hold on. I'll let you speak in a second.
That's all I have. Just that we're working to have him probated to a state facility bed. And we need, you know, ample time to make that discharge plan happen while he's incarcerated.
I'm not going to a hospital, Lindsay.
Okay.
I'm not
All right, so
going to a hospital.
Mr.
I'll stay
Newman.
right here. Yeah.
Mr. Newman, is there anything that you would like to say about the charges that you're being charged with? Anything else you
They're
want
all
to say?
ridiculous. They're ridiculous charges. They're all lies. I read the report. They're all lies. The whole house smokes in their room. They smoke blunts in their rooms. This lady has no control over that halfway house.
Okay.
They clam bake the bathroom every night. I'm in trouble for smoking. I didn't smoke. They are racist. How is that a crime to call someone a racist prick when I'm defending my rights? They discriminated against me. I was hospitalized twice for high blood sugar. I'm not going to take a toxic dose of insulin. She violated my rights so bad. That's why I'm agitated, and I'm not going to a state hospital. No way in hell I'm going to. I'll stay right here until I'm on probation.
All right, sir. So let me go through the charges and make my findings.
Please defend me, Ms. Jones. I'm not going to a state hospital. I have probation in 14 months. I'll just stay right here.
Sir, that's not what we're talking about now. We're not talking about the state hospital now. This is just about your
she
parole
just talked
violation.
about it, and I would like to defend myself and tell you there's no way now I'm going to a state hospital. You're abusing
if I could just add one thing,
special parole.
if I could just make one last comment, I would just point out also that when Mr. Newman was seen at Yale New Haven, there was a follow-up appointment that was scheduled for March 28th of 24 at 1 p.m. And obviously he was unable to attend that appointment based upon this remand. And I think that certainly it would have been helpful had he attended that appointment, so we could have had some idea as to whether or not the change in medication was staying, how his insulin was doing, or if they were going to change that in pill form or as opposed to an injection, but he wasn't able to attend that appointment based on this remand.
Okay.
But anyways, Lindsay Carrington.
His medical appointment, he refused to attend. He had one the day before on the 14th as well, and he refused to attend.
You know why? Because I have a lawsuit with Yale, and I told Greg I have a lawsuit with Yale. My lawyer advised me not to go near Yale. I have a primary care physician, and I'm not. And if I run out of medicine, I can go see her. I have a lawsuit against Yale. Last thing I want to do is go see a doctor that's giving me a toxic dose of insulin, who I have a lawsuit against. So that's why I didn't go to that doctor's appointment.
All right, so let me go through my findings with respect to the charges of the parole violation. So charge number 1, condition of halfway house placement. Regarding the first paragraph of the refusal to take the insulin, I do make a finding of probable cause based on evidence provided by the state, specifically the medication refusal forms. So we don't have evidence. It sounds like P.O. Carrington back up. I don't have any evidence of that. I just have evidence of the failure to the 2-1, 2-2, and 2-5. So I am making a finding of probable cause based on the information provided by the state on those specific 3 dates. Charge under the paragraph of smoking in the bathroom. I am making a no finding on this charge based on the evidence, the argument by defense. There was nobody that saw him smoking in the bathroom. Yes, there was smoke in the bathroom. However, I am making a no finding on that charge. Charge under the verbal aggression with the disrespect and verbal aggression with the staff. I am making a finding of probable cause based on evidence provided by the state, specifically the reports from the halfway house. And charge number 2 under mental health treatment. I am making a finding, just like the other paragraph, on the 2-1, 2-2, and 2-5 of the not the 2-12 or 2-13, since the was stopped by Yale New Haven Hospital. All right.
Can I say one more thing?
Sure.
Lindsay is in cahoots with my abusive family, my abusive parents, and she's working for them. They're the ones trying to get me into a hospital. They've been trying to make me a ward of the state the whole time I was in the halfway house. And Lindsay is working for them, with them. Okay. They're abusive. I have a trailer. I have no problem taking care of myself. I lived alone since I was divorced in 2007, I guess. I have a beautiful life, but my parents are working with Lindsay Carrington. She had the whole house wrapped around her finger, my abusive mother, and that's who the doctor and Lindsay are working in cahoots with. Okay. So I don't know what kind of PO works, listens to an abusive mother, but it's pretty sick, in my opinion. You're trash, Lindsay.
All right, so I did make a finding on some of the behaviors. There was a no finding on one, and a few dates in there I did make a no finding on. I do find this behavior serious enough to warrant revocation, and I have determined that you should be detained while you wait for your revocation hearing. So it will not be me, it will be a different hearing examiner doing the revocation hearing, probably in the next month or two, I would say. and they will get that scheduled as soon as they can, okay? So this concludes the preliminary hearing for David Newman, 323-865. All right, thank you. Good luck to you, sir.
Thank
Whatever. F you, Lindsay. You freaking
All right.
bitch.
All right, David, I'll reach out to you soon to go over the remainder of the case, okay?
I'm not going to a hospital.
Okay. Thank you.
I'll stay
You're
right
all
here
set,
until
sir.
my probation starts.
Kristen, please disconnect. Thank you.
Something in the water, right? But in all seriousness, this is a sad case. It does seem like it's someone who's struggling. We also are seeing issues with, you know, what the board member kind of said was, wait a minute. So he has a Yale doctor that says maybe this medication isn't working, and he shows up in DOC, and his DOC doctor says, no, you should start the medication. And that's wow. That's, I don't know, is the word polarizing the right one there? You have Yale on one hand, and you have the DOC on the other. But, you know, that's the interesting thing about Connecticut. And this is part of what I love about doing these different states. You see the cultures, and to remember, you got Yale and you got Harvard, and you got, it's the academic state, right? But there's something wild about what happens in Connecticut when it comes to inmates and DOC. Now, this man, it's dangerous. I don't know what happened to him, but he's by no means can you just let him out. And the idea that they did let him out to a boarding house or whatever they call it, halfway house, taking into account his escalating crimes. And thank you, Richard, for sharing it. Before we jump into that, we are going to have to see his final parole hearing. So what I think I'm going to do is keep this in membership only. And then when his final hearing comes, I'll tie it all together as a larger hearing and show it to the public. But this way, I think you'll have some insight into that. I think that's a good approach. Let me know in the comment section. I mean, either that, or I wait until I have all the hearings, or I push it to the public and just let everyone know that there'll be a continuation. I'm not sure, still figuring it out. But let me show you this.
Roommate with a knife. It happened at the victim's home in the 100 block of Gina Circle. News 12 Connecticut's Marissa Alter is there with developments. Marissa.
Eric, this is not a street that police say they're usually called to, but this home behind me became a crime scene yesterday morning. That's where police say 42-year-old David Newman lunged at his roommate with a knife while the victim was washing dishes. He was stabbed in the shoulder, wrist, and arm, but police say the victim was able to fight off Newman by using a stun gun on him and kicking the knife away. Police say the victim called 911, and when police arrived, Newman surrendered without incident. I'm told he didn't give any indication about what prompted the attack. But the victim, who is now back home after being treated at the hospital, says Newman has a history of mental illness, including bipolar disorder and schizophrenia, and he'd stopped taking his medication.
It's the first for us going there for this, and we're happy that nobody was killed, and it's a good thing that the roommate was able to fend him off and stop the attack.
Now, the victim didn't want to go on camera, but he did tell me that he'd been letting Newman stay here with him for the past couple months as a favor to his family. He also tells me he is very grateful that he had that electronic stun gun in his pocket. Otherwise, this could have ended far worse. In Stratford, Marissa Alter, News 12, Connecticut.
Well, there you have it. And I was gonna say, I was thinking, wow, who carries a stun gun on them in their house while they're doing dishes? And apparently this man does. That might tell you all you need to know. But he was charged with attempted homicide, and I guess and this is his record is this is just the tip of the iceberg. We're going to go view another one soon, but he has a long record. And again, when you see this information, it probably makes you say, wow, how is it that he's, keeps getting kind of these light sentences? His last offense, where he got robbery, second degree, which we're about to see, he got sentenced to 10 years jail, but suspended after 3, probation 5. And as we can see, he's right back in where he started. But let's look at the last offense, which he received just most recently.
In Hamden, police are investigating an incident where they say an 85-year-old woman was robbed in broad daylight.
Now, the incident happening at the Hamden Plaza on Monday. For more on this, we're joined live in Hamden by Fox 61's Zania Maldonado. Zania.
Well, Brett and Amanda, like you just said, this robbery took place in the busy Hamden Plaza on Monday in broad daylight just before 4 p.m. Hamden police say that 85-year-old woman was unloading groceries into her car when she was dragged to the ground by this suspect who tried to steal her purse. Now, police say the suspect approached the woman from behind as she was unloading her groceries. The man then grabbed her purse and she was violently pulled to the ground. Police say that suspect then drove away from the scene in a blue Honda CRV, which had been stolen earlier out of West Haven. The suspect is only described as a dark-skinned male who was wearing a full face mask. Back in February, there was another parking lot robbery that took place just a little bit further down Dixwell Avenue at the Stop and Shop Plaza. A 63-year-old woman was robbed of her purse while putting groceries in her car and dragged about 40 feet. Now, police say as a result from being pulled to the ground in this incident, that 85-year-old woman did fracture her shoulder. She's asking anyone with information to contact Hamden Police. Live in Hamden, Zania Maldonado, Fox 61 News.
Now we are going to fast forward to June 11, 2024. So we saw his hearing on 4/4/24, 5/16/24, and now June 11th. This is the actual parole hearing where they go in with the evidence that was permitted, and they're going to set a date. And man, I feel bad for Lindsay, is what I can say. With that, let's jump in.
Is this for Newman?
Yes, it's for Newman. Yes.
Oh, by the way, he's coming right now. Hold on, give us a second.
Okay, no problem. Thank you.
My bad. I didn't know you had 11:30. So
I do. I'm like, oh, I have to look at the calendar. I have to look at the schedule to make sure everything's still running on time.
I'm sorry. I'm sorry.
Okay.
Take care. Here you go. This is Newman. David. Yeah.
Hi, Mr. Newman. Your attorney is currently in another proceeding. She should be with us within the next 10 minutes. Thank you.
They keep him waiting for 14 minutes, and I thought it was a good idea to keep that footage in because it might be telling in the way that he kind of sits there and stares into the abyss. But I'll put it on 4x speed. Let's go.
Okay, Mr. Newman, we're still waiting for your attorney, just as an update.
Yeah, she's a waste of space anyways. Can we just get started?
No, we cannot. She is in another hearing right now. So as soon as she's done with that hearing, which would be momentarily, she'll be in and we'll be right with you.
Well, it's quite ridiculous.
All right, thank you. We'll be right
I'm
with you.
only in agony.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning David Newman, 323-865. Today is Tuesday, June 11th, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Gardner Correctional Institution. Please state your full name and DOC inmate number for the record.
David Newman, 323-865.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Newman.
And P.O. Carrington is also present. Good morning, P.O. Carrington.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence that is the weightier or better, or the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of the evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Newman and P.O. Carrington, please raise your right hand. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we review the parole charges that the state your parole officer is bringing against you. Then I will review and identify exhibits for the record. The state will have an opportunity to present all relevant testimony, subject to cross-examination and any relevant documents. After the state is finished, your attorney will have the same opportunity. After considering all of the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, your attorney will have the same opportunity. Do you have any questions regarding the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I will now review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violations. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We will now review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. Carrington, you may begin with charge 1, halfway house placement.
On the following dates, you refuse to take your prescribed medication of insulin: 2/9/24, 2/10/24, 2/12/24, 2/13/24 twice, 3/9/24, 3/10/24, 3/11/24, 3/12/24, 3/13/24, 3/14/24, and 3/15/24. This is a violation of the signed halfway house agreement and your parole condition of halfway house placement.
It's not a condition of my special parole to take medication, P.O. Carrington. It's not a condition. Stop lying.
On the following date.
That's complete fabrication.
Mr. Newman, we're going to allow the PO to read the charges, and then you're.
But that's a false. She's lying because that's not a condition of my parole.
Okay, so she's just reading the charges that are bringing against you. She's just reading.
But she's lying about the charge.
Just let her finish reading it, and then we can.
If you knew my rights, you would say this. She's lying. That's not a condition of my special parole to take medication, especially insulin.
Okay. She has the opportunity to just read the charges without interruption,
She's lying
and then we'll get
for the third time.
them.
That's not a condition of my special parole to take medication.
Okay, there was on April 16, 2024, there was a preliminary held, and there was a no finding on dates February 12, 2024 and February 13, 2024. You may continue reading the charges, P.O. Carrington.
On the following dates, you refuse to take your prescribed mental health medication of Depakote: 2/1/24, 2/2/24, 2/5/24, 2/12/24, and 2/13/24. This is a violation of the signed halfway house agreement and your parole condition of halfway house placement. On 2/13/24, you were observed on camera going in and out of the bathroom multiple times during third shift. Staff went in to check on you and found the bathroom smelling of cigarettes with smoke in the air. No other clients had access to the bathroom at this time.
A lie once again.
On
He's lying.
2/2/24, you became combative with the program staff and refused to follow staff direction. You refused to listen to staff and entered a staff office after being instructed to wait. You called staff a racist asshole and a racist fuck. This is violation of the signed halfway house agreement and your parole condition of
I
halfway
called
house
him a
placement.
racist prick, Lindsay. You are such a liar. You are such a liar.
On charge 2, mental health, there was a no finding. There was a no finding at the preliminary hearing on April 16th, 2024, on February 12th and February 13th. You may proceed.
Okay. On the following dates, you refused to take your prescribed mental health medication of Depakote 2/1/24, 2/2/24, 2/5/24, 2/12/24, and 2/13/24. This is violation of the signed halfway house agreement and your parole condition of it should be mental health treatment.
It's not a condition of my parole. Burn in hell where you belong, Lindsay Carrington. Burn in hell. You are such a liar.
Mr. Newman, we're going to continue with the hearing, okay?
It's bullshit.
A preliminary hearing was held on April 16th, 2024, and the state exhibits were marked and identified on record. There was no further evidence provided by the state, and the defense has filed the following exhibits. Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses. P.O. Carrington, at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted.
I mean, since his release, he was only out for about 2 months. He was hospitalized pretty much 75% of that time as a result of not being compliant with medications and not being stable. But once he was released back to the halfway house, he continued to refuse his medications.
To hospitalize me, Lindsay. No reason to hospitalize me. I was abused and tormented in that halfway house. I was traumatized by Dana House. Your staff abused me.
Mr. Newman, your attorney will have an opportunity to represent you.
My attorney didn't even call me. She doesn't even know this. And she works against me, might I add.
Okay. You okay? Anything further?
Yeah, just that, his non-compliance with medications was pretty much life-threatening at the point of his remand to custody.
Life-threatening? Are you crazy?
He was very threatening toward others, still remains very threatening.
Oh, stop lying, Lindsay. Threatening. Oh, you're full of shit. You're full of shit, Lindsay.
Mr. Newman, can you grab the CO for me, please?
For what?
I would like him to come into the room.
Oh, yeah?
Please.
This is bullshit. This is bullshit. Fuck you, Lindsay. Burn in hell where you belong. They want you to come in here. You're such a liar, Lindsay.
Officer?
Hey, David, as I indicated, you and I did speak. I don't know why you're saying we never spoke.
We spoke 3 months ago.
But if I can just finish, David, as I indicated, P.O. Carrington is allowed to read the charges, and she's
lying.
She's allowed to make comments. We are also allowed to make
I'm allowed to make comments. I'm defending myself. She is lying.
You are allowed to make comments, but we have to give her the opportunity to complete her comments.
She is lying.
Officer, so if we can please let her complete her comments prior to us addressing those comments.
You guys requested me?
Yes, I would like you to mute him while the officer is making her statement. We're going to mute him until she's done making her statement, and then I'm going to inform you when we can move forward.
All right. You good?
Yeah, they're railroading me, that's all.
All right. So you're going to mute him?
Yes, and then once...
All right, just give me the thumbs up and I'll take him off mute.
Okay, thank you. P.O. Carrington, you may proceed.
His behavior has been aggressive toward others. I'm just recommending a 4 to 6 month sanction. He had a probate hearing a few weeks back where he has been determined to be involuntarily committed to the hospital. So a 4 to 6 month sanction will allow us appropriate time to obtain a state bed for him and work on that discharge plan because he needs to be hospitalized.
It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. In regards to the paragraph beginning on the following dates you refuse to take your prescribed mental health medication, I would just point out that Exhibit H, which is an after visit summary from Yale New Haven Hospital, with the instructions state that your medications have changed, and it indicates stop taking Depakote. Now that report is dated February 6th of 24. They added metformin, which is a medication to help control high blood sugar, which would obviously in this case be the resulting would be the type 2 diabetes. So presently my client is not prescribed Depakote. So I would simply be pointing out that if he was not prescribed Depakote on February 6th, this violation is talking about him not taking Depakote on 2/1/22/25. So obviously that was not a necessary medication for him to be taking, or it would not have been removed on February 6th. In regards to the paragraph,
oh, I'm sorry.
In regards to the paragraph that begins February 13th of 24, I would just note that there was a no finding as to that paragraph at his preliminary hearing, though P.O. Carrington did read that information into the record. In regards to charge 2 under mental health treatment, I would make the same comments regarding the after visit summary from Yale New Haven Hospital, Exhibit H, instructing that my client's medication had changed and that he was to stop taking Depakote and that metformin was added. And presently he was not prescribed Depakote. Exhibit K, which was the physician's emergency certificate from 2/14 at Dana House, indicates that he was not taking his prescribed medication of Depakote. However, it had been removed previously on that February 6th date. And then I would just point out that three of the dates that are alleged to have occurred prior to my client being seen at Yale New Haven Hospital when it was documented that the Depakote be stopped. Certainly it's logical to believe that Mr. Newman was not in need of Depakote on February 6th. He likely was not in need of that medication on the 1st, the 2nd, and the 5th as well. My client also was not in disagreement with taking insulin. He was disagreeing with the form and the dosage in which they were attempting to give it to him. They were attempting to give him an injection as well as a dose that he did not necessarily agree with. Having that metformin was added. I would also point out, well, I can address this in my later comments, but that is all I have as to the charges. And I don't know if you would like to unmute him now. So
okay. Officer, you can unmute him.
Can I just add one thing?
Maybe don't unmute him yet.
Well, P.O. Carrington, you would have a moment to make a closing statement. Is it before a closing statement, or is there something else you want to
I just
now?
wanted to add about the Depakote that the hospital discontinued it, but his prescriber, his psychiatrist, the next day when he was returned to the program, did restart his Depakote.
Okay, so officer, you can now unmute Mr. Newman.
He did not.
Okay. Go ahead, Mr. Newman. Refrain from any threats. You could make a statement regarding the allegations.
No threats. Are you deaf? Threats.
No aggressive language towards the officer. Please just make a statement regarding the allegations of charges against you.
And if I can just add, in regards to the medication being added back, I believe that the physician that met with him indicated that he was unable to meet with him in person. He attempted to meet with him by way of video and was unsuccessful with that, and had a telephone conversation with him. And I would just indicate that does not seem sufficient to be adding back a medication that an in-person hospital stay stopped him from taking. And those would be my only comments back to in regards to what P.O. Carrington just indicated. I certainly don't disagree with her that occurred. I just think that based on a telephone conversation that was alleged to have taken place with my client, that is not sufficient to place him back on a medication that an inpatient hospital stay removed him from. But Mr. Newman, My suggestion would be that we go forward with letting the hearing examiner make her determination, and then we can speak again in terms of your background and history and some other comments that I do have to make in your defense.
A 6-month stay, that's a year sentence
But we're
under
not even there
50%
yet.
law.
Comments to make in regards to that, sir.
Well, it's absolutely ridiculous.
I don't
was
disagree with you,
hospitalized for
but
no
we,
reason.
let's let the
It's-
hearing examiner make her findings, and then we can go forward and address what you're attempting to address right now, okay? Thank you.
Any P.O. Carrington, would you like to make a closing statement before I announce my findings?
Just, I just want to reiterate the sanction of 4 to 6 months, for appropriate discharge planning, because he is gravely disabled and the only place that he can discharge to is an inpatient hospital. And we need the
That's
time
not true.
to obtain a bed for him.
I did 4 years in here. No judge committed me to a hospital. I did 4 years in here. I deserve my freedom. I did nothing wrong to be incarcerated. I did nothing wrong in that halfway house. If I don't want to take insulin, that's my prerogative. It's not a condition of my parole that I take insulin nor Depakote. I take the meds they prescribe. Depakote doesn't agree with me. I did nothing wrong.
Defense, would you like to make a closing statement before I announce my findings?
No, that's referred as to background and history. Okay.
I'm sorry, 6 months in here is a year sentence under 50% law for doing what? Nothing?
Mr. Newman,
Do
I'm
you
gonna make
really
my
believe no one had access to the bathroom with cigarette smoking?
That's not, Mr. Newman, there was a no finding made on that particular portion of that charge.
Oh,
So we
well,
don't
I didn't
need to
hear
talk
that,
about
sorry.
that, okay?
I didn't hear
So-
that. Okay,
okay.
forget about it.
So on charge 1, halfway house placement, no finding of probable cause was made on parts 2 and 3 for 212 and 213 at the preliminary hearing held on 4/16/2024 and will not be considered at today's revocation hearing. I make a finding on the rest of the parts of this charge based on state's exhibits A, D, E, F, G, and H, and I. On charge 2, mental health treatment, a no finding of probable cause was made on 212 and 213 at the preliminary hearing held on April 16th, 2024, and will not be considered at today's revocation hearing. I make a finding on the rest of the dates of this charge based on state's exhibits A, D, E, F, G, and H. This concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney would have an opportunity to speak to your background and history. The purpose of this revocation hearing, this part of the revocation hearing is to help determine what outcome I recommend. But first, we're going to start with P.O. Carrington. Do you wish to make a statement regarding Mr. Newman's background and history at this time?
Nothing further than what I've already stated, both today and in the preliminary.
Counsel, do you wish to make a statement regarding Mr. Newman's background and history?
Yes, thank you. My client's 48 years old. He's single. He has no children. He is a high school graduate. He does hold a bachelor's degree. When he was in the community, he was supported by disability. Some of the things that I would note would be that the recommendation was for a higher level of care. My client is essentially being remanded for failure to take medication, some of which was not prescribed during specific dates. A higher level of care, in my opinion, is not the Department of Corrections. And it's not Mr. Newman's fault that there is not a bed available for him. Being in jail is not an alternative to the state's failure to find a bed for him, as the probate court has indicated. There certainly are halfway houses that are available to him. I'm certain that there are halfway houses that are available to him, and why he should sit in jail for 4 to 6 months, the recommendation of his parole officer, while he waits for that higher level of care, does not seem reasonable to me for the charges that are alleged here. He does have certain rights, and I understand when he's on parole, he's giving up some of those rights, and that he does have to, agree to take prescribed medication, mental health medication. Some of the things that I also would note in this particular situation is that Mr. Newman was prescribed at some point, and that's noted in Exhibit K, as well as Elazar, and both of those medications are known to cause high blood pressure, high blood sugar, or diabetes in this case. patients are typically prescribed metformin to control weight and consequently to control their blood sugar as well. As we know, Mr. Newman was being supervised by the mental health unit, and we know obviously there's reasons for that. He was not born with diabetes. Rather, that's something that he developed as a result of the side effects of the medications that he is taking. And I don't know that anyone ever explained to him why he's even taking these medications. I don't know. We know that he was prescribed metformin at Yale New Haven Hospital, but we don't know if anybody really explained to him why he was taking.
I know what metformin. You don't need to. I'm college educated. Okay, I know what metformin is.
It seems as though when the emergency certificate was ordered, the doctor was not aware that Depakote was ordered stopped and suggested it as an add-on medication. And again, certainly the least restrictive means would be to start Mr. Newman, put Mr. Newman back into the community in a halfway house while he waits for that bed to open. It wouldn't be to leave him in jail because there is no bed available for him, and the higher level of care recommended is certainly not something that can be found within the Department of Corrections for him. So we are asking that he be re-paroled at the next available date, just noting that this violation is a failure to take medication, one of those being insulin, and the other one being a medication that was removed by Yale New Haven Hospital when he was inpatient there. So that just does not seem reasonable under these circumstances that he should sit in jail for any more time. He's been held in custody now since March 15th. Certainly the least restrictive means and a higher level of care is not something that's found within the Department of Corrections. He should be in the community while he waits for that state bed to open. So our request would be that he be re-paroled at the next available date. Thank you.
P.O. Carrington, do you have anything else to wish to say before I make my recommendation?
Yeah, just that he's not eligible for any halfway house due to his mental health needs. He is not allowed back at Dana's house. They will not take him back there. And I just want to reinforce his threatening and aggressive behavior towards others. And that was a huge part of why he was removed into custody as well.
Shut up, Lindsay. Threatening behavior. What are you talking about?
And he can't.
You're crazy.
When he does discharge from DOC, he will have to go directly to the hospital. A halfway house won't be an option.
You're a liar. You're a liar. Threatening behavior. What threatening behavior, Matt? What threatening behavior?
Defense counsel, do you have anything else to add?
The only thing I would add is I don't have any proof that there's no available halfway houses for him in the state of Connecticut. I find that hard to believe, but I don't have any proof that there are not any.
I find it very hard to believe.
I just think that, the recommendation initially was for a high level of care, and I just don't think that that's reasonable that higher level of care is to be found within the Department of Corrections.
I recommend revoke special parole with a re-parole date of July 15th, 2024, which is an approximate 4-month sanction. I recommend the following conditions: no contact with victims Gary Esposito, and stay away from Cumberland Farms, located at 1023 Boston Road in Milford, Connecticut, a halfway house placement and mental health treatment. My findings and recommendations we forwarded to the board. You will receive official notice from the board. Your board review is scheduled on June 27th, 2024. The board may lessen the recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of a panel of the board. This concludes the revocation hearing.
I'm sorry, I missed the date. So re-parole date?
7/15.
And if I can inquire of P.O. Carrington, do you have any documentation from probate that just indicates what the recommendation was, just so I can include that in my file?
Yes, I can email it to you. We have the commitment decree.
Yes, if you wouldn't mind emailing that to me, I would appreciate it. Thank you so much.
Because all she did was lie to the judge.
Okay. So this concludes the hearing for Mr. David Newman, 323-865. Thank you.
Thank you.
Burn in hell, Lindsay.
Poor Lindsay. Oh gosh. I mean, I really don't know what to make of this. His special parole date ends June 2025. So he's got one more year where he has to somehow manage not to get revoked. If you're, and they basically sanctioned him where he has one more month left to serve, which is pretty much, so he was arrested. He first got locked up on March 15th, and he had his preliminary at 4/14, then at 5/16, and then finally at 6/11 here, and one more month. And I guess so they're not sending him to, I guess he gets to go where he wants. That I missed that part. Frankly, it's 5:30 in the morning, and I'm trying to put this. It's like multiple parts where you put these things together. He needed that other attorney. I would have loved to have seen him represented by the other attorney, Mr. Macalanetti, if I'm pronouncing his name right. He would have put up a good fight. I don't know what his attorney really had to work with in this case. The man is not, he's not dumb. He's just might be crazy. But if you listen to what he's saying, actually, it's like, hey, I didn't say anything threatening. Don't say I'm threatening, because I'm not. He's just speaking his mind. He's just telling his parole officer to burn in hell. You would think that at this state they should just switch parole officers. Like, that should have been part of the mandate. This obviously isn't going to work. This is not going to work. I don't know if they can do that. You would think the parole board could have maybe ask the parole officer if she wants to switch. It's not a great relationship here. I don't know the answers. Remember that he initially was locked up for randomly stabbing his roommate. Then he went into a store, robbed $3 and robbed from a grandmother and dragged her. So, he's dangerous. He attacked a police dog. I don't know if I want to do that with you, but following a foot chase, I don't know who attacks a police dog. You got to be a different kind of crazy. When officers tried to pull him over, police say he ditched his car, then attacked a police dog. Officers eventually deployed a stun gun and took him into custody. So this was the 2017 incident. The most recent incident, which was, and thank you, Richard, for providing this info, which we already went through. I mean, his record, it's long. It's a long record. I don't know why they think it's, he's getting, what can you say? 2021 was when he, in Cumberland Farms, they stay away from Cumberland Farms. That's where he stole $3 at 4:30 p.m. He walked into the store, pointed a knife, though, at the cashier and demanded the money. The employee gave him $3 that was sitting on top of the register. The suspect then exited the store after investigation. 45-year-old Newman into custody at his home in Milford. He literally went into a store with a knife. I don't know what, maybe you got to stop giving these light sentences. Maybe he needs, clearly this is a mistake to let him out. What tells you that he's going to not offend again? That's what's scary to me. Anyways, I don't know what else to add. I feel bad for Lindsay. Poor Lindsay. And with that, I'll let you go.